Finally, I turn to the case of Tinkler and the Commissioners of Her Majesty's Revenue and Customs, whom I will refer to as HMRC. This case is about the doctrine which lawyers refer to as estoppel by convention. In essence, this doctrine operates to prevent a party going back on an assumption that has been shared with and acted on by the other party when it is unconscionable to do so. The appeal in this case has presented this court with the opportunity to clarify the precise requirements of estoppel by convention in the context of dealings between, on the one hand, HMRC and, on the other hand, a taxpayer and his tax advisors. The taxpayer is Mr. Tinkler, and his tax advisors are BDO Stoy Hayward, whom I will refer to as BDO. On the 1st of July 2005, HMRC sent a letter to Mr. Tinkler, copied to BDO, with a covering letter, notifying Mr. Tinkler that they were opening an inquiry into his tax return for the tax year 2003-2004. Unfortunately, the letter was mistakenly sent by HMRC to a previous residential address of Mr. Tinkler and was not forwarded to him, so that he never received that letter. HMRC and BDO, acting on behalf of Mr. Tinkler, then exchanged various letters about the details of the tax return, and several years later, on 30th August 2012, HMRC issued a closure notice ending the inquiry and clarifying the tax owed. Mr. Tinkler disputed that the tax was owed, and, prior to the start of the case before the first-tier tribunal, Mr. Tinkler for the first time raised the point that HMRC had failed to give him a valid notice of inquiry because they had sent the letter opening the inquiry to the wrong address. He therefore argued that the closure notice and its conclusions were invalid. HMRC counter-argued that Mr. Tinkler was prevented by estoppel by convention from relying on the non-receipt of the letter opening the inquiry. The first-tier tribunal held that estoppel by convention was made out by HMRC, but a different view was taken by the upper tribunal, albeit that the upper tribunal found against Mr. Tinkler on different grounds. And the Court of Appeal, in finding for Mr. Tinkler, also considered that HMRC could not succeed on the estoppel by convention argument. HMRC now appeals to this court on the estoppel by convention issue. This court unanimously allows the appeal of HMRC and holds that Mr. Tinkler is estopped by convention from denying that an inquiry was validly opened. The main judgment is given by Lord Burrows, with whom I, Lady Arden, and Lady Rose agree. Lord Briggs gives a short judgment concurring with the judgment of Lord Burrows. In this judgment, Lord Burrows examines the leading cases on estoppel by convention in English law before turning to the most relevant case, which was the decision of Mr. Justice Briggs, as he then was, in HMRC and Bench Dollar Limited. This also concerned non-contractual dealings between HMRC and taxpayers. Mr. Justice Briggs set out 5 principles for the operation of estoppel by convention in this context. The Supreme Court approves and applies and explains further the reasoning behind those 5 principles. If we call the party alleging estoppel by convention C and the other party D, those 5 principles can be summarized as follows. First, there must be a common assumption of fact or law made by C and D, and it must have been made clear by words or conduct that is said to cross the line between them, that they share that common assumption. Secondly, D must have conveyed to C that D expects C to rely on the sharing of the common assumption, such that D may be said to have assumed some element of responsibility for C's reliance on the common assumption. Thirdly, C must in fact have relied on that common assumption. Fourthly, that reliance must have occurred in connection with some subsequent mutual dealing between C and D. And fifthly, C must thereby have suffered some detriment, or D must thereby have been benefited in such a way as to make it unconscionable for D to assert the true position. This court explains that underpinning the first three principles is the idea that C must have strengthened or must be strengthened or influenced in its reliance on the common assumption by the knowledge that D is affirming the common assumption. Also that D must intend or expect that that will be the effect on C of its affirmation of the common assumption, so that one could say that D had assumed some element of responsibility for C's reliance on the common assumption. Applying those principles to the facts of this case, the court holds that estoppel by convention is made out. Although BDO did not have the apparent authority of Mr. Tinkler to receive the notice of inquiry, in all other respects in relation to the inquiry, it was acting as the agent with the apparent authority of Mr. Tinkler, and BDO, on behalf of Mr. Tinkler, had made manifest to HMRC that it was sharing the common assumption, and, as BDO must have intended or expected, BDO's affirmation of the common assumption strengthened and influenced HMRC in thereafter relying on that common assumption. Moreover, there was no statutory bar under the Taxes Management Act 1970 to the operation in this way of estoppel by convention. While this case concerned estoppel by convention in relation to non-contractual dealings, the Supreme Court takes the view that the 5 bench dollar principles are also applicable more generally, that is, in relation to contractual dealings. Lord Briggs, in his short concurring judgment, explains why he agrees with Lord Burroughs' analysis of the bench dollar principles. The appeal of HMRC is therefore allowed. The court will now adjourn.